Good afternoon, everyone. Thanks for being here at the Jackson County Prosecutor's Office. I am Jean Peters Baker, the prosecutor for Jackson County. So we have an announcement today, so not to leave everyone in great suspense, we sent out an earlier announcement. So today, my goal is to provide you with a little bit more clarity and reasoning behind the decline. I'll start by telling you on May the 15th of 2018, the St. Louis Circuit Attorney, Kim Gardner, announced that she was dismissing an invasion of privacy charge against the then Governor, Eric Greitens. Her office announced it would be appointing a special prosecutor to examine the evidence. Fast forward a week to May 21st, my office was named as special prosecutor, and then the following day, on May the 22nd, we received the circuit attorney's file. And then we were off and running. And we've been running hard since that date. Now, since then, the statute of limitations has been looming large on us. And so a team of prosecutors in my office, along with the Missouri Highway Patrol, we have exhausted every potential lead we could find. And before I go any further with my comments, I do want to acknowledge some help that I received. I really want to express my gratitude and my thanks to the Missouri Highway Patrol for their assistance in this case. Once I called for their help, they jumped in. And I received some of the very best investigative agents in the state of Missouri to work with me on this case. I'm not going to name them, but they should know that I was very honored to work with them. And though I stand at this podium very much aware that I stand here alone, I did not work this case alone. I had a solid team of prosecutors and these professionals from the Missouri Highway Patrol, and I want to thank all of them for working so far beyond the call of duty. So here's a little bit of what we did when we got the case. Since May the 22nd, we issued subpoenas for the House Committee and other records. I want to thank the House Committee as well for how cooperative they were in providing records to us. It's been difficult to get cooperation in other places. We collected statements from witnesses who had not yet been interviewed, and we sought a forensic exam of one of the suspect's phone, of the data of his phone. Though I want to make it very, very clear that we do not know for certain what phone may have been used. There are multiple phones that could be used. Our investigation revealed that a review of the suspect phone was actually conducted by the defense team in April. And our investigation then discovered this new fact that was discovered on June the 1st. So we had to move quickly to try and get our arms around that data. How could we get that data, and how could we review that data? So after jumping through many hurdles, we reviewed this material at our very, very first opportunity. That occurred this week on Wednesday into the evening and into the next day on Thursday. I'm talking about just yesterday, by the way, June the 7th. The lawyers that took over this task on behalf of this team, I'm not going to name them either, but they know who they are, and I want to thank them for being willing to drop everything, drop all responsibilities that they have. And for those of you who have ever worked in an assistant prosecuting attorney's office, know there's always work to do, always. No one gets a day off, and no one really has the ability to drop files. So in this case, they set aside other priorities, and they jumped into this review. And they worked literally through the night to provide us some answers. The Highway Patrol also assigned a forensic examiner to us so that we could have a better understanding of that material. Yesterday afternoon, we determined that at least 31,000 viewer files existed between the April extraction and the May extraction of the suspect phone. In the case that we received, we only received from Kim Garner's office a May extraction of that data. So I'm going to say that again because it's important that you understand. The April extraction that we only learned about, our investigative team only learned about days ago, had 31,000 more files than the May extraction. I cannot begin to express my level of frustration in simply trying to get potential evidence in this case, especially working against the clock. Subpoenas in this particular case we knew were of limited value because of the time frame of which lawyers know they can run out the clock on you. But here we are. Here we are, and effectively the clock has run out for any review for the invasion of privacy case. So enough about that and my extreme frustration about that. I want to move back into the case itself and what we were able to do. On May the 24th, a team that included myself, an assistant prosecuting attorney, and Missouri Highway Patrol agents, we traveled to St. Louis immediately in order to begin some additional work. On that date, we met with the victim in this case. And as you know, a victim is never placed in the shoes of determining whether or not a prosecutor files a case. That is not their job, and that is not their burden to carry. It is mine. But victims and their willingness to pursue those charges does inform a prosecutor's decision. As of today, with the statute of limitations about to expire within hours, we do not have sufficient evidence to consider filing new charges in this case. We have exhausted our investigative efforts based on what we could find, and simply corroborating evidence for the invasion of privacy case could not be found. In fact, the evidence would rest solely on the victim's statement for any charge during the time frame of which we were assigned a review. We also reviewed the facts for offenses that included domestic assault and sexual contact without her consent. Some of those statute of limitations had already run, and so we worked with available statutes that were that we hoped were still in play. In my interview with this victim, she made clear she did not wish to go it alone. Without other evidence to support her accounting, she just didn't want to go it alone. In the words of this victim, quote, "My heart just can't bear it." That statement still weighs heavily on me. In my interview with this victim, it helped inform me about the route that we should take. She alone would carry the burden of these charges. But along with this victim, I agree it's too heavy a burden to reach beyond a reasonable doubt standard. So let me talk now just a bit about the victim in this case. She's received much attention, but I'd like it to bring it back to a different type of attention. And I'd like to bring this back to where this case should have begun, and that is with her. She is the center of this case, and while most of the attention has been on the politics, the future of this or that public official, or the impact on political power, the victim has largely stood alone and unprotected. She has undergone repeated attempts to discredit her. Now look, I am a prosecutor, and I understand that all victims must undergo scrutiny. That's not what I am talking about. And I understand that as the victim in a high-profile case involving a politician, this victim would face tough examination. That's fair. But her repeated testimony remained consistent, in spite of repeated questioning in multiple forums. So I'm going to give you a little bit of a partial list of what was required of her for this case. On January the 10th of 2018, her secretly recorded confession about an affair was exposed, all without her consent. The recording was without her consent, and the release of that recording was without her consent. On or about January the 24th of 2018, she agreed to meet with the St. Louis Circuit Attorney. She did so. On January the 29th, she gave a video recorded statement to an investigator from the St. Louis Circuit Attorney's office. On February the 15th, she testified to a grand jury under oath. On February the 22nd, she testified a second time to a grand jury under oath. On March 7th, she testified and was questioned before a Missouri House committee. On April 6th, she testified under oath in a deposition conducted by defense lawyers, which lasted about 9 hours. On April the 25th, she testified again under oath in a deposition conducted by defense lawyers. And on May the 3rd, she testified a third time, again under oath, questioned extensively by defense lawyers. On May the 23rd through the 24th, the House committee read verbatim her testimony into the record. And on May the 24th, myself, an assistant prosecuting attorney with me, and the Missouri Highway Patrol, we met with her as well. And she was also willing to speak with us. And if not for the governor's resignation, she would have been required to testify again on June the 5th, this time to a House committee. And she was ready to do it. However, she never wanted this. She never willingly came forward, but she did tell the truth. Some of the questions she faced were less than respectful, and one could easily surmise some of these questions were nothing more than attacks to discredit her. And I'm going to give you some of those because I want you to understand what I'm talking about. This is from defense lawyers, and these are not my words. Who did your boobs? Do you have a belly ring? Are your nipples pierced? Are you a liar? And I wish that had only been asked once or twice, but I lost count, quite literally lost count about the number of times she was peppered with being a liar in her deposition. She was asked about whether photos obtained from a fetish website depicting a woman tied up and other photos of two people engaging in sexual contact were in fact her. Now, I'm not going to hold you in suspense. They weren't. They were not her. The victim in this case has received no benefits, but there is evidence that her ex-husband expected to receive financial payments for the secret recording he released without her consent. And yet, the ex-husband has faced very little scrutiny. Now, I'm hopeful for one thing, and that is that today the vicious attacks against this woman will stop. The attempts to discredit and humiliate her will stop. She deserves to be protected from further harm. I'm going to do my best now to protect her from that future harm. And to anyone who has attempted to harm her, I hope you can defend yourself and your practices. What is important to note about this victim through all of this is that she did not waver. Though she repeatedly faced a large, aggressive team of expensive lawyers, I'm told that list may be as high as 40 lawyers, she held her own. And I have a message to other victims of similar crimes. Please know this. The doors to this courthouse and the courthouses around the state of Missouri are open to you. We want to hear from you. Even when we cannot prove a case beyond a reasonable doubt, we want to hear from you. In fact, we need to hear from you. This courthouse belongs to you as much as it belongs to any criminal defendant. Justice on behalf of victims must be sought by all of us. And as a prosecutor today and in the future, I will not stand silent, nor will I tolerate that kind of behavior against victims in a case. It's time that we come together and we stand up for victims and future victims, and that we encourage them to come forward and inform us about what all of us need to know. I know this statement has already been released, but I do have a statement from the victim in this case. I want to read that statement to you, and then I want to take some of your questions. Well, I won't, but I will. I will take some of your questions, to be more honest. This is on behalf of the victim in this case, and Scott Simpson is her lawyer. He is the individual that released it, and I think we have some copies of the statement that we will pass out. My client and I would like to thank the members of the Special Prosecuting Attorney's Office and the investigators from the Missouri Highway Patrol who worked tirelessly on this case. She is grateful to all who have supported her and believed her testimony. That support lifted her spirits and helped her through this challenging time. No woman should have to endure the trauma that comes from her ex-husband selling her private story for a six-figure payout. No woman should have to turn on the television and watch as the most private and difficult moments of her life are broadcast despite pleading with the reporter for privacy. No woman should be forced to answer countless hours of highly personal questions that are in no way relevant to the issue of whether a nude photo was taken without her consent. The most intimate details of her life were made public by a vengeful ex-husband and a second man willing to spend millions of dollars spreading lies about her in an effort to save his political career. My client did not ask for any of this treatment, nor was she paid or otherwise compensated. No legal funds were created, and no pleas for donations were made by her or on her behalf. As my client and the citizens of this state move past this difficult time in Missouri's history, we hope other women in similar situations are not discouraged by this process. It takes real courage to testify once, let alone 6 times. But that courage exposes the truth. So that is on behalf of the victim in this case, and I'm happy to take some of your questions.
Statute of limitations notwithstanding, do you believe that there was a probable cause for some sort of assault charge or a sexual battery charge?
Yeah, probable cause, yes.
Can you elaborate?
No, but we don't have proof beyond a reasonable doubt.
If you
There's
had
a
more
difference.
time,
So you would have filed it had there not been a statute of limitations problem?
No, I think we needed additional cooperation. In regard to your question regarding additional cooperation, that's what we needed. We needed more cooperation in this case. And in fact, for me to go forward on this case, it would be the victim alone, and she would get beat up again. I would protect her as best I could, but it puts a whole lot of pressure on a single person to carry a single case.
If you had more time.
What does it say about the law, though, that this woman's credible testimony in and of itself was not enough? I mean,
Yeah.
what does it say just generally about all these cases that a woman credibly testifies, told the truth, and it's still not enough to bring the
Yeah. So
defendant
that
to justice?
therein lies the criminal justice system. This is a very tall bar. We're not talking about probable cause. Probable cause is a lower bar. Proof beyond a reasonable doubt is tall. It's hard. It's difficult. And the reason for that is we don't want to include individuals in the system unjustly. We do not want to charge individuals. We would rather the guilty go free than the innocent are convicted. That's why the bar is tall and hard and tough. Every case stands on its own individual merits, so I'm not saying that there would never be a case where this wouldn't get you there, but this victim helped inform my decision with her words, and they still weigh heavily on me today and standing in front of you.
To follow up just briefly, doesn't that make it harder for women to your office and say, I don't have any proof, all I can tell you is what happened, and you said it isn't enough.
So we do that every day. We do that every day. What we try to do, though, is we do it with compassion. We do it with offering services and help to individual victims. And sometimes, we are able to go get more corroborating evidence so that we can make that case happen. That's what's important to us. So this is not an exercise where you throw something against the wall and you see what sticks. That's not the criminal justice system. And that is not the burden of a prosecutor. It offends me when I hear people say that. Our burden is much higher than that. And we are officers of the court. We are officers of the system. So for us, we must consider all factors, whether or not we have proof beyond a reasonable doubt.
With regard to the charge, the possibility of sexual assault, and you said that wouldn't have gone forward under you because of the statute of limitations. I'm wondering if, because as a special prosecutor, would that have been within your purview, or would you have had to hand it off to someone?
We believed that we got to review conduct that occurred regarding this victim and this suspect during that time frame. And that included potentially other types of charges. This got complicated because literally the clock of statute of limitations was ticking so loudly when we received it. And so there was very little time for us to go back and kind of rework cases from a different angle or a different charge. We did look at those things. Some were already beyond statute of limitations, some were questionably beyond, but we believed after we met with the victim in this case and hearing her words, it wasn't enough to get us to an indictment.
How did you learn again about the April cell phone extraction that it sounds like you said Mr. Greitens' defense team did?
Yes.
How did you learn about that?
We were able to subpoena records a little bit early on in the case. I say early on, but we're literally talking about days. I've lost track of the time, but it's days. But we issued one subpoena, and the guy agreed to fill it before the full 10 days ran. Thank God. And in our interview of him with Highway Patrol agents, he let us know that he also reviewed the phone in April. So that was new news to us.
He reviewed a phone in April, or is this a different one than Special Master Callahan reviewed back in May?
So there was a May extraction of the phone. There was a special master assigned to that May extraction. We learned only, I think I said on June the 1st. I may have my dates a little mixed up because, like I said, we've been running, so days have flown into the next day before we realized it. But when we learned that there had also been an April extraction of the same phone, we started running to see what we could get from that data, and as much data as we could get from it. What we learned was there was a big discrepancy between those two extractions.
Okay, so that's why.
Does
that mean
witness
evidence
still
was
believe
deleted?
there was a
Does that
picture
mean
taken?
evidence was deleted, to your understanding, potentially, was evidence deleted if there were 31,000, you didn't get to review those 31,000
Correct.
files, so they were destroyed in between?
They're gone. I know that they're gone. Whether or not they were intentionally deleted, how they were deleted, why they were deleted, that I do not know.
Do you believe there was ever a picture, and do you think if you had more time to investigate this, that you would be filing charges against the former governor?
I think I find this victim extremely credible. I find her credible. And I believe her statements about being photographed are true. She had stood nothing to gain by telling us that. She did not wish to take the governor out. That was not her purpose. She had no vendetta. She made mistakes. She made mistakes, and she told the world about them.
Do you think if you had more time, you'd be able to prove that?
I think here we are, and we ran this as late as we could. Maybe there's a couple hours left today, but we really used the last few minutes. In fact, we were still attempting to gather additional evidence today, literally today. So I can't really answer that. I can tell you that the clock ran out and that we did what we could during the time frame that we had.
Now, her husband, she says that she was tape recorded without her consent, and it was released without her consent.
Correct.
Could he be criminally liable for something, for doing that to her?
It doesn't appear so.
Did the governor's team ever offer his resignation in exchange for you dropping your investigation?
There were very minor, but there were negotiations in that regard. I think this is not, while some cases it may be appropriate to quit your job, walk away, maybe that's appropriate for certain types of cases, but really no, for this fact pattern, that really is just not appropriate. That doesn't settle the score. It's not justice. And while you may perceive this as not being justice either, we believed it was better to just let's run it through. Let's keep running and let's finish our investigation and see where we can get.
Which statute of limitations, if there was more than one, did the clock run out on? I'm unclear whether or not you look at it.
Well, there's a 3-year statute of limitations.
No, I get that, but were you looking at 3 possible crimes, or 5 crimes, or 2 crimes? I mean, the statute of limitations on incidents here.
There are a variety of misdemeanor crimes that we looked at where the statute of limitations had clearly run. So stalking, harassment, there's an invasion of privacy misdemeanor charge. Those were gone by statute of limitations. And we are, as you know, we are beyond 3 years right now. The date in question was March the 21st. There was a tolling that occurred because the case was filed and there was a period of days that it told. But it's literally, we think this weekend, tomorrow, the statute of limitations is
Jamie,
foreclosed.
With regard to the probable cause, I think you said probable cause,
Mm-hmm.
you thought there was probable cause for sexual assault charges.
Yes.
But they weren't brought. How frustrating is that for you?
You know, this is a frustrating job. It's not an easy job, and it does require. Prosecutors should always be willing to look at all possible evidence, but you have to also understand that when you're talking about sex assault victims, you're talking about a special kind of victim. It's not as if some victims we don't care as much about, but I'm saying a sexual assault victim, you have to weigh what they can bear. It's important that you weigh those two things together. And so, yeah, I'm frustrated, but I also believe that this is the right decision based on the facts and the law that we have and being informed by the victim in this case.
But in terms of, you had said earlier that you deal with cases on a daily basis where there's not enough to get a conviction and that kind of thing. What I'm wondering is, when you have a man in a position of power like this, does that add to your frustration? Does that add to your heartache about it?
I don't believe this man is any different than, even a homeless man, maybe a guy with a lesser job than governor. The behavior is abhorrent. It's awful. And while he was in a position of power, that is something that we think about. But for me, what I had to do in this case is really put that aside. We actually even talked about this as a team. The possibility that he'll remain our governor, the possibility that he won't resign, the possibility that he won't be impeached. It all just had to be, we had to just numb our hearing to that because it wasn't appropriate for prosecutors to make decisions based on all of those things. So yes, it's frustrating. Yes, it is frustrating, but it is also our job.
Based on your review of the case, do you think St. Louis Circuit Attorney Kim Gardner's office mishandled this case at any point? Were there steps her office could have taken if they had done something differently would have increased this woman's opportunity for justice?
So there are different types of conflict that can happen. Sometimes there's just the appearance of conflict, and sometimes it's just a particular individual in the office that has a conflict and you maybe can wall it off. In this case, we had an absolute conflict, for whatever this is worth, if this helps answer this question. Kim Gardner, we viewed her immediately as a potential witness in our case, and that meant her entire office. So what we were hamstrung in not being able to pick up the phone or call a meeting and sit down and discuss what was your strategy. Why did you file that charge? Why did you take, why did you go down this path evidentiary wise? So we really just couldn't do that, and I to date have not done that because she was a potential witness and I needed to treat her as such. So those are questions probably that are best for her to answer. They're not questions that I can answer because we did not, we couldn't share information that way and protect the case.
Given your
Just a
decision
quick
today,
question, just to clean up some loose ends, did you ever find a picture?
No,
Incriminating picture, you did not?
we did not.
Did you ever speak with the governor, or did the investigators ever speak directly with the governor?
We did not speak with the governor. We requested, and he has a right to exercise that constitutional right, and he exercised it.
So there was no questioning ever of the governor, under oath or under any circumstances at all, through your team?
He exercised his right to silence. Yes.
given your decision today, do you think Gardner's office was correct in bringing the charge, the invasion of privacy charge in the first place?
A little bit like I already said, I don't think I can answer that based on all that she reviewed, what her analysis was. I can tell you what mine is. My review, as I picked this up, I don't know, 2 weeks ago, 3 weeks ago maybe, I don't remember now. But during the period of time I had it, it was to review the case that I had. And from my perspective, an invasion of privacy charge was just too high a bar for us to get over without cooperation for the victim. Additionally, other potential charges were, where there was sexual contact or domestic assault because they were in a continuing romantic relationship with one another. Could those have been charges? That too was without cooperation. So the victim stood alone. So that's the main decision.
How would you characterize the cooperation that you got from the governor's defense team?
Oh, I'll pass on that. Anyone else?
What does it mean you'll pass on that?
I'm not going to answer the question is what I'm going to say. I'm not answering your question. Anybody else?
Did you ever get to investigate who gave Al Watkins the $120,000?
Look, that was another sort of interesting sidebar of this story, but we believed that had really no credible relevance to our evidence in the case. Those are definitely add to some other interesting intrigue in the case. But we really didn't have time to go down that arm of the case and to review who gave the money, what was it for, and so ours was to stay within the four corners of our case itself, and that was touched on our case, but it was too far outside of what we had time to deal with.
Did your office have any contact with Greitens legal team since the resignation? You seem to.
Yes,
yeah.
We did.
Can you describe that contact at all, or?
We invited them here. They came. They talked to us, and there was nothing really, of great consequence that came of that meeting that changed anything for us. So we knew we had to keep marching forward and kind of exhaust every other lead we could. All right. Anybody else?
James,
Any other
just
questions?
to be clear on the probable cause with regard to the sexual assault possibility, you didn't file that, you didn't move ahead with that specifically because the statute of limitations prevented it?
Specifically because probable cause is not proof beyond a reasonable doubt. And the victim in the case couldn't bear that on her own. Those are her words, and I wanted to honor that. So for me, that was really without cooperation, as we kept trying to find cooperation, we couldn't, and so that's where we ended.
So the statute of limitations really didn't figure into no additional charges with regard to?
No, those statute of limitations were serious issues for us, and those were going to be issues that if we felt we were going to file a case there, we were still going to have to fight, and I'm not positive we could have even prevailed on a statute of limitations claim there, to be blunt. We knew that was going to be another very long and deep legal fight, and we weren't sure we could win.
Do you have any idea what happened to the other phones?
No, we don't. We do not know. We do not know.
You investigated the invasion of privacy, sexual assault, and any other crimes that you investigated?
The possibility of some domestic assault related offenses. And then, of course, there were some misdemeanors that, we talked about, but of course, they were already gone.
So there was invasion of privacy, sexual assault, and domestic assault?
Yes.
How many phones are we talking about here? Pardon me, but
I don't know.
more than 5?
The House committee thought we had maybe 5 phones that were at play. So we had one that we were able to review.
You mentioned your office interviewed new witnesses who hadn't previously been interviewed. Anything you can tell us about what you learned from those witnesses?
They were, we felt like we should just go a little broader in gathering some additional witnesses, and all I can tell you is that, it didn't net anything for us. There were witnesses that we thought we needed to do. We needed to make sure we were being complete and thorough, but it didn't. Obviously, I'm not standing here with another answer for you. So, all right. With that, folks, I'm gonna exit. I thank you very much for being here today. And Mike has a statement of the victim.
Do you need one?
Thank you.